Picture this, a homeowner is locked in a battle with a TikTok-famous squatter who refuses to leave. This isn't just any squatter, she even teaches others how to take over properties. In court, she confidently claims she's moving out and has returned the keys, while arguing she only owes a fraction of the rent and disputing late fees. Meanwhile, the homeowner paints a very different picture. $15,000 in unpaid rent, unauthorized roommates, possible sublets, foreclosure threats, and even losing health insurance because of this chaos. The tension escalates as Judge Simpson tries to regain control. He rules in favor of the homeowner, giving them the authority to secure the property and change the locks that very day. He also sets a non-jury trial to sort out the money issues, requiring both parties to appear in person, or via Zoom for the men involved. But it's not just about this one property. The case highlights a bigger problem. Current squatter laws are slow, complicated, and can leave homeowners helpless while non-paying occupants stay protected. As the squatter argues wrongful lockout and seeks damages, the courtroom becomes a battleground of entitlement versus responsibility. Every moment is a clash of conflicting claims, legal loopholes, and real-life consequences. Homeowners across the country face similar struggles, and this case shines a spotlight on the flaws in the system, forcing us to ask, who really has the law on their side?
I'm also on this case. Jared Lepick,
Yes.
Unfortunately was diagnosed with influenza A this morning, so he had his Zoom going and can mic in if need be, but he's got very little of a voice at this point.
Okay. All right. And yes, I do see him signed in. All right. Andrew Elliott or Traversia, is it Burrell?
Traversia Borelli.
Okay. Sorry.
That's
All right. Okay, what are we doing on this case?
Last week, sir, you had asked that they be out of the house before the hearing today. And as of right now, they're still moving stuff out of the property. There are still people on property, including a couple of unauthorized additional roommates that weren't included in the lease. And we have yet to get in contact with Mr. Elliott. He is the named person on our lease. So we would just like to see what his status is. We haven't heard from him since the 7th. And the last thing we received from him in writing was an email admitting to the debt owed and the wrongdoing on his part. Obviously not refute what you are owed. We have no intention to. We would honor the court decision of the debt, which would additionally include legal fees. Given our contract is under the laws of Michigan, there is very little that can be garnished as the bulk of my earnings are earned as independent contractor. In this email, he proposed a payment plan that we were uncomfortable with agreeing to because he's offered us specific payment arrangements over the last.
Can I stop you, please?
Absolutely.
All right. How much are you claiming is owed?
So as of right now, he owes $15,000 plus court costs of $234.43. If I may, could I give you like 90 seconds of backstory, sir?
Not really.
Okay.
Your Honor,
I don't know that I'm necessarily going to need it.
Okay.
Ma'am, are you moving out?
Yes, we've returned the key. I have a couple of friends currently helping me move out the remaining things. I'm actually at the U-Haul Center right now, and they are getting the rest of the items out presently under the supervision of the land manager.
Okay. So, and ma'am, are you disputing the amount they're claiming is owed?
I am.
You are?
Yes, I am. We owe.
How much do you think you owe?
So we owe December and January. That's $10,000. We paid a $1,000 late fee in November and a $2,000 late fee in September and October. We believe that these should be subtracted from the total owed due to illegality of those fees. Also, we were subjected.
How much is monthly rent?
Your Honor, monthly rent is $5,000 a month. This is a 4,000 square foot house that we were under contract for them to purchase. And we have done a series of short-term leases as they were waiting on the state.
Okay. So here's the thing. Is she right about, she just listed off, I think, $4,000 of late fees that they paid.
No, sir, that is incorrect. Those were from the previous lease. See, at first we did a 60-day lease, and then we extended that once their house was not sold. So we have 2 prior leases to this short-term lease, and we only enforce late fees on one of the months under those leases. And I can submit documentation of all this, sir. I do have claims that ACHs were sent that were never received to my account, sir, as well as proof of funds that I received in December, and no payment was made out of that. The last communication I had about a payment arrangement was on December 13th. And I was informed by Mr. Elliott that day that his wife had sent an ACH. However,
okay, look, folks. Oh, ma'am, here's what's going to happen. What date are you going to be out of the premises?
We're already out.
Your stuff
You're
is
already
still
out.
Right.
And they have surrendered the keys?
Yes, and it's in the process of being removed as we speak. So we are out. It'll be another hour or 2, I think, before it's all of our stuff is gone.
Then the only issue is what's owed.
Right. I also want to bring up, if I may, Your Honor, we were subjected to a wrongful lockout, so we are due 3 times damages of the $150 for a locksmith as outlined in Michigan's anti-lockout statute, totaling $450, which I also have evidence of.
Okay. All right,
Your
look,
Honor.
folks.
Your Honor, house because they failed to pay rent. I have 6 children. These people make $350,000 a year is what they claimed on the rental application. I'm going to lose health insurance tomorrow, and my house is going into a foreclosure period as of tomorrow is 90 days late. They have money. They had subletters or whoever living with them, and I don't know if they were running a homeless shelter, if they were pocketing the rent that their roommates paid. They've just been sitting in my house, sir.
This is incorrect.
Okay. All right. So here's the thing. Possession has been granted. There are 2 parts to the case. Possession's been granted or surrendered to the plaintiff. So possession is not. Sorry. Pardon?
There are still people at the house. One of them had a residence established there, apparently. They're still at the house, and unfortunately our property manager expired at noon today, as it is the last day of the month. So any clean out of anything left behind, I'm going to have to go assess for any damages left on my own next week.
All right. Okay. So here's what I'm going to do. They've surrendered possession of the unit. Ma'am, to your knowledge, are there people in the premises?
Yes, there is.
Are there people still in the premises?
I don't know. I would have to text them. I don't know if they're on the premises presently, but we were told that we could get the remainder of the items out. So they would be doing that if they are not presently at the U-Haul Center where I am now. I'm just using my phone to do this.
Possession to the premises has been surrendered. Ma'am, as of, given everything that I'm hearing,
Yes. And we can't afford to pay a property manager anymore.
Hang on. I hear you. I'm just trying to, because you're in North Carolina, right?
Yes, sir. But I will have to make a trip up to North Carolina to assess anything.
I know. I guess you're out of state. You've got a property manager here that won't be the property manager tomorrow.
Yes, sir.
So what? I should let you guys talk, and then I'll just go back and then come back out. Because either you're going to listen to me. Possession's been surrendered. I'm going to give the authority. I'm going to grant to the plaintiff the authority to prevent waste under 4.201I, that you may lock and secure the premises effective 3:00 today. The reason I'm doing that is so that you can get your property manager, go over there. You can order a locksmith. You can change the locks at 3 p.m. today. Whatever else needs to get out, if you don't get it out by that time, you said you surrendered, you're giving them the keys, they giving you grace to get some of the stuff out. If it's not out, not out.
That's perfectly fine, Your Honor. Thank you.
Then the issue regarding the money is going to have to be done. Now, I might as well, because the parties don't seem to agree, set this matter for trial. You have to come up next week. Is that correct, ma'am?
Yes, sir.
Okay, so trying to time this, if you come up, how long are you going to be up here?
Very short amount of time, sir, as I have children in North Carolina in school. So a day.
Okay. So if I set, well, I was just going to set this for a trial. So I can set a trial date, but I'm going to need the parties in person because apparently there's going to be a lot of documentation. So I'm trying to set it. So here's what I'll do. Because we're really talking about the money, but we got to get the premises secured first. So we've dealt with that. What's my date? March the 4th? 11th. All right. So what I'm going to do is I'm going to set a non-jury trial as to the money issues for March 11th, 2025 at 9 a.m. That's in person. So I've tried to set that, ma'am, I tried to set it out far enough so that you could make arrangements or do what needs to be done to come up. We'll hear it that day. So if it has to be a one-day trip, it's a one-day trip. But I've just tried to put it out to, well, I think you get what I'm saying. Okay?
Absolutely.
But I'm allowing you to secure the premises. You're going to come up here, check on it. That way you can assess what damages or other things there may be there. Bring ledgers, all other documentation you want the court to look at on March 11th, and then we'll hear your case. Okay?
Your Honor, might I ask one question?
Sure.
Other than pushing it out, I can make arrangements. I will make it work. Like I said, we're actually going into a 90-day foreclosure period tomorrow. And so time is kind of of essence.
Got it. Then the best I could do is the 18th. What day? Yeah. The best I could then do is February 18th. I could push it up to that day. Will that be better for you?
Yes, sir. Thank you so much.
So non-jury trial in this matter then will be set for February 18th, 2025, 9 a.m. Okay.
One more question. Will Mr. Lepek have to appear as well, or will me be appearing sufficient just because he can't afford time off of work right now?
Well, he might want to have himself, if you're here, he may want to have himself. I will allow understanding childcare, work, those things. I would allow him to appear via Zoom.
Thank you. And as far as Mr.
So that he's present, but you will have to be here in person.
Understood. And Mr. Elliott?
He needs to appear. If he doesn't appear, then I do what I got to do.
Okay. Thank you, sir.
Your Honor,
Thank you.
may I ask a question?
Sure.
My partner might not be able to get off work either, but I can show up. Is that a problem?
I will give you the same. Okay. I will give you the same opportunities that I give the other side in fairness. So you may appear, but he would have to be available.
This is a story about a homeowner who found themselves in a nightmare many property owners fear but rarely talk about. A TikTok famous squatter, someone who openly teaches others how to occupy properties without permission, refused to leave a home they had been living in. From the moment the case hit the courtroom, the tension was undeniable. The squatter appeared confident, almost entitled, insisting that they had already returned the keys and that they were moving out. They argued that they only owed rent for 2 months and that any late fees should not apply because, in their view, those fees were illegal. On the other side, the homeowner's representative presented a very different reality. They explained that the squatters were still occupying the property, had brought in unauthorized roommates, and owed more than $15,000 in rent plus court costs. There were also allegations that the squatters had sublet the property, possibly collecting rent from others while the homeowner struggled to regain control. The financial pressure on the homeowner was immense. They were facing foreclosure and even losing their health insurance because of the prolonged legal battle. Every word in the courtroom felt heavy with consequence, and it became clear that this was not just a dispute over property, it was a fight for survival and justice. Judge Simpson handled the situation with a mix of patience and firmness. He listened carefully to both sides, acknowledging the squatters' claims while also recognizing the serious impact on the homeowner. In his rulings, he granted the homeowner immediate authority to secure the property and change the locks by a specific deadline, ensuring that they could protect what was rightfully theirs. Additionally, he scheduled a non-jury trial to address the financial disputes, requiring all parties to appear in person or via Zoom for any male participants. His decisions underscored the importance of balancing legal procedure with the urgent need to prevent further harm. As the hearing progressed, the squatter attempted to argue that they had been wrongfully locked out and sought damages for alleged mistreatment. Their arguments, however, only highlighted the complexities of squatter laws and how these laws can sometimes create more confusion than clarity. The homeowner, meanwhile, had to endure the stress of navigating a slow and expensive legal process while dealing with the real-life consequences of lost income, threats of foreclosure, and the emotional toll of seeing their home occupied illegally. The broader implications of this case extend far beyond the single property. Current squatter laws, while designed to prevent abuse, often end up protecting those who refuse to pay rent or violate agreements. Homeowners frequently bear the burden of legal fees, court appearances, and the emotional strain of trying to reclaim what is theirs. Cases like this shine a harsh light on the imbalance, showing how ordinary people can be caught in a system that favors the wrong party. Every detail of this courtroom drama tells a story of entitlement clashing with responsibility. The squatter's bold claims and the homeowner's urgent pleas reflect a struggle that many face but few discuss openly. This case also reveals how social media can amplify unusual behavior, with the squatter's online presence adding a layer of public scrutiny to an already tense situation. People watching from home see not just a legal dispute but a real-life conflict that raises questions about fairness, justice, and the human cost of ineffective laws. Throughout the hearing, it became increasingly clear that this was not just about money or possession, it was about accountability and the consequences of choices. The squatter's insistence on disputing rent and fees, combined with attempts to claim wrongful treatment, created a scenario that tested the patience and judgment of everyone in the courtroom. The homeowners struggle to maintain control over their property while managing the personal impact of the situation makes this case resonate far beyond the legal documents. Judge Simpson's rulings emphasized the need for immediate action while still respecting the legal rights of both parties. By allowing the homeowner to secure the property and change the locks, he prevented further unauthorized occupancy. By setting a trial for the financial disputes, he ensured that the questions of owed rent, fees, and damages would be addressed in a fair and structured manner. The balance between urgency and fairness, enforcement and due process, was at the heart of this courtroom drama. The story also brings into focus the human cost of these legal battles. Homeowners like the one in this case face sleepless nights, financial instability, and emotional exhaustion as they try to navigate a system that often feels stacked against them. Squatters, on the other hand, may exploit loopholes and ambiguities, creating situations where the law appears to favor occupancy over rightful ownership. This imbalance fuels frustration and raises questions about how laws should evolve to protect property owners while still ensuring fairness. Watching the proceedings, it's impossible not to notice the stark contrast between the squatter's confident demeanor and the homeowner's anxious persistence. Every claim, objection, and ruling contributes to a story that is both dramatic and educational, shedding light on the complexities of property law and the human stories behind legal disputes. Social media attention, courtroom procedures, and real-life consequences all converge to make this a case study in how entitlement, law, and justice intersect. The narrative of this courtroom battle is more than just legal jargon, it's about accountability, rights, and the real consequences of choices made by individuals. It shows how homeowners can be forced into prolonged struggles to protect their own property, highlighting systemic challenges that often go unnoticed until a crisis occurs. Every ruling, objection, and statement contributes to a layered story of conflict, struggle, and the pursuit of justice. As the trial moves forward, the outcome of the financial dispute will have lasting effects on both parties. But the hearing itself already serves as a powerful reminder of the challenges inherent in current squatter laws and the real-world impact on homeowners. It's a case that blends drama, legal complexity, and social commentary, capturing attention not just for its unusual characters but for the very real lessons it teaches about property rights, accountability, and the human cost of flawed systems. This courtroom showdown is a microcosm of a larger issue. It forces viewers to consider the balance between protecting individuals from abuse and ensuring that homeowners are not left helpless. It exposes the frustrations, vulnerabilities, and struggles faced by those whose lives are disrupted by unauthorized occupants. The story is tense, dramatic, and at times infuriating, but it is also deeply human, a clash of entitlement versus responsibility, law versus consequence, and social media fame versus real-world accountability. By the time the hearing concludes, the audience is left with more than just a verdict. They are left with a sense of the complexity of property law, the emotional weight carried by homeowners, and the challenges of navigating a system that can sometimes favor the wrong side. Every twist, every argument, and every ruling contributes to a story that is as educational as it is gripping. In the end, this case serves as a reminder that property ownership comes with responsibilities, risks, and sometimes battles that extend far beyond what anyone expects. It shows how laws, courts, and individual actions intersect in ways that can profoundly affect lives. The tension between the squatter and homeowner, amplified by legal procedure and social media, creates a narrative that is equal parts cautionary tale and courtroom drama, leaving a lasting impression on anyone watching.